sworn. If you raise your right hand first, please. You swear affirm to tell the truth, the whole truth, nothing but the truth?
Yes.
If you have a seat, ma'am, if you'd state your name and then spell it for our record, please.
Michelle Rose, Michellerose.
Thank you very much. Ms. Goldberg?
Thank you. Good morning, Dr. Rose.
Good morning.
Would you please indicate for the court what your occupation is?
I'm a veterinary radiologist.
And is radiology a specialty for you?
Yes.
How long have you been practicing veterinary medicine?
I've been a veterinarian for 16 years, and I've been a veterinary radiologist for 10 years.
Okay. Is there some kind of certification or anything that you need special to be able to call yourself a specialist in veterinary radiology?
Yep, a specialty in radiology requires a residency, which is 3 additional years of training and passing the certification test.
Okay. And then once you pass the certification test, are you a member of the board?
I'm a member of the American College of Veterinary Radiology.
Okay. Thank you. And where is it that you work?
I work at Blue Pearl Veterinary Partners.
Where did you receive your educational background?
I went to veterinary school at the University of Tennessee, and I did my radiology residency at The Ohio State University.
Thank you. First, I would ask if counsel would agree to stipulate that Dr. Rose is an expert in veterinary radiology. If not, I'll ask the court.
So stipulated, Judge.
For purposes of exam only. Go ahead, counsel.
Thank you very much. In your job at Blue Pearl, Dr. Rose, did you have the opportunity to review some records and x-rays that would have been sent to you by a Dr. Begany at Eastpointe Animal Hospital?
Yes.
Okay. And do you remember approximately when you had the chance to review these films?
March 24th.
Okay. And do you recall how many you reviewed?
Yes, I looked at 2 x-rays of the thorax and 2 x-rays of the skull.
Okay. Can you describe what you mean when you say thorax?
Of the chest area.
Okay. And was there anything that your review of those x-rays caused you to take notes of?
Yes, on the chest x-rays, there were 2 rib fractures on the left side. And there was on one of the views, the lung was wider than normal, which would indicate that there may have been some contusions or bruising to the lung.
And is that on the left side as well, did you say?
I was unable to determine that.
Okay. But that was to the lung.
Mm-hmm.
Is that a yes?
Yes.
Thank you.
When you see x-rays showing rib fractures, in your experience and your training, is that consistent with trauma, or can it be?
Yes.
Were you able to arrive on an approximate time frame for when the injuries could have occurred based on your review of the x-rays?
Yes.
And what factors do you, well, first of all, what was when you made a projection as to what the time frame was, how old those injuries were, what was your opinion?
My opinion was that they had occurred at less than 4 weeks, likely in the range of 1 to 3 weeks.
And what factors do you consider when you look at that?
So there was not a callus starting to heal the fractures, so that would put them at less than 4 weeks. They were not, I didn't consider it to be an immediate fracture of 1 day duration because the margins of the fractures were a little bit smooth.
Okay, what does that mean if they're smooth?
That means that they are subacute or chronic. They didn't occur a day ago. When a fracture immediately occurs, the margins of the bone will be sharp.
Okay. So if it's 1 day approximately, then you see sharp margins?
Mm-hmm. Yes.
Okay. And when you say chronic, what does that mean in veterinary lingo?
Chronic is not acute or subacute, so it varies depending on the injury or what organ, but a chronic change is something that takes time to develop.
Okay.
So the smooth margins that I see would indicate that there had been some days that had passed before the fracture occurred.
Okay. But it doesn't, you don't mean it in terms of like a chronic problem, long-standing, months and months or years or anything like that. It has a specific meaning in your veterinary radiology world, the word chronic, that helps you determine time frame?
Well, Judge, I just object to leading.
Well, I'm sorry, I'm just trying to clarify.
Rephrase that.
Sure.
Thank you.
Dr. Rose, I guess I'm just asking, that specifically means to you chronic would be less than 4 weeks. Is that what you're testifying?
In this case, the chronic itself does not mean less than 4
Okay.
weeks.
Okay. In this instance, based on the x-rays, that's what you're saying?
Yes.
Okay. And acute would mean 1 day?
1 day, maybe 2 days.
Okay. I just wanted to be clear. Thank you. For a dog to have fractured ribs, is there a requirement that there be an application of force?
Yes.
And why do you say that?
Because all of our bone structure the bones are strong, and it would require a high force to actually break them. The rib cage is there to protect our internal organs, so there would have to be a high force to break those.
Okay, thank you. And based on your training and experience as a veterinary radiologist and as a veterinarian before that, would fracturing ribs cause a dog physical pain or feel unpleasant?
Yes.
Have you had a chance to review the video of the incident that's alleged to have occurred here today?
Yes.
And based on what you saw in the video, are the dog's injuries or the injuries in the x-ray consistent with the person in the video's actions?
Objection, Your Honor, calls for speculation as well, and it calls for an ultimate conclusion of fact.
Judge, I don't believe,
Response?
I'm not asking that she say that person did it and for sure it happened. I'm asking for consistency, like we talked about with the last witness. She is an actual radiology expert, and I believe she is more than appropriate to be able to answer that question. Certainly if the other witness was allowed to make that answer and give her opinion, I think Dr. Rose is more than qualified.
And I think, once again, the question isn't whether or not these acts are the ones that created these injuries, but in fact whether or not they're consistent. And so it's two different questions. So I'm going to allow that question. Go ahead, doctor. You can answer that question.
Can you ask the question again?
Sure. Are the injuries you observed on the ribs and possibly the lung as well consistent with the actions of the person in the video you watched?
Yes.
I have no further questions.
Cross-examination?
Dr. Rose, you indicated you viewed that video, is that correct?
Correct.
Okay. And you indicated that these injuries could be consistent of what you viewed on that video, is that correct?
Yes.
Okay. Now, you're familiar with, you talked about force, is that correct?
Yes.
How much force was generally necessary to crack a canine rib?
I do not know how much force in physical terms, like I don't know how many pounds per square inch it would take to crack a rib.
But commonly ribs are cracked by car accidents, things of that nature, correct?
Yes.
Now, during the course of the video, did you ever see watching that video, did you ever see Mr. Sporer strike that dog in the area where that rib fracture occurred?
Yes.
With what?
His knee.
His knee.
Mm-hmm.
Was that the portion where he's pushing the dog into the house?
No.
Okay. What portion, when you make your indicate that these things were consistent, what strike would you say would have possibly caused this injury?
He pushed his knee into the left side of the dog's chest at the same time as he slammed the right side of the dog's chest up against a door. So there was force coming from both sides at that time.
Are you saying the portion where he's next to the house then?
Yes.
Okay. Now, you indicated that a breaking of rib would be painful, correct?
Yes.
So a dog would generally, when in pain, would bark or show some type of injury, is that correct?
They might, yes.
Okay, and you don't know if that dog barked or anything at that point in time or yelped
Correct.
But generally, a dog that breaks a rib is going to either show some sign of injury at that point in time. Is that correct?
They could, yes.
But is it likely that it would?
It is likely.
Okay. And it would be very unlikely if the dog had a broken rib that it would not bark or not show any signs of injury. Is that correct?
I don't know if every single dog would bark every time it got traumatized or had a fracture.
Okay. Now, you simply reviewed the x-rays, is that correct?
Correct.
Did you have a chance to view the dog's medical history at all?
I had a history from Dr. Begany that stated that there was trauma, and she indicated to me that there had been trauma to the head and the thoracic region. I did not review her medical notes.
Okay. Your view of the x-rays indicated absolutely no trauma to the head of this animal, is that correct?
Correct.
Okay. No abnormalities to the head or the skull, correct?
That is correct.
Okay. You also typed up a report of this, is that correct?
Yes.
Forward that to Dr. Begany, is that correct?
Yep.
Now, you indicated that the rib fracture, left side rib fractures, did you list a rib number or anything on your report?
Yes.
Okay, and you indicate what, these are 8 and 9?
Correct.
What is a displaced fracture?
That means the rib is not lined up appropriately.
Okay. So does that mean that basically it is not in the shape it previously was? Or?
Correct.
Okay. Would you have been able to determine if this was in regards to fractures, was this a complete break?
Yes.
Okay. And when you see a fresh injury on an x-ray, what indicates to you that this injury just occurred?
Of a bone?
Right, correct.
If it had immediately occurred, then there would be sharp margins.
Okay. And
at the fracture line.
Okay, so you mean, describe what sharp margins at the fracture line mean.
They would not be fuzzy. They
Okay.
would, if you look at it, it looks like a distinct line.
Okay. And in reviewing Meatball's x-ray, there was some fuzziness then, correct?
Correct.
Okay. And you indicated that that this fracture may be chronic, which we've kind of gone over what the definition is. But does it indicate that you thought this injury occurred at least over a week ago and perhaps over 3 weeks ago?
No,
Well, let me ask you this. Did you put in your report that when you wrote chronic that it was 1 to 3 weeks?
yes.
Okay. So that means 1 to 3 weeks is not what you meant.
I don't understand.
Well, did you mean that the injury you believed was at least more than a week old?
It could be. That is my estimation. Bone healing is a continuum. It's not a definitive. I can't look at a healing bone and say this definitely occurred at, or a fracture and say it definitely occurred at 4 days, or it definitely occurred at 6 days, or it definitely occurred at 3 weeks. It's dependent on age of the animal and if there's motion.
Okay, so...
So I needed to give a range.
Okay, so your range that you gave was 1 to 3, is that correct?
That is, yes.
But that's just you indicate that the range could be different than that, correct?
It's possible that it could be potentially 5 days old. It's not older than 4 weeks.
Okay, it's not older than 4 weeks. Is there any time that it's not newer than?
Doctor, how did you determine that it was...
Objection.
I'm sorry.
Hold on. Counsel, we're not going to have you bounce back.
Absolutely, Judge.
You're going to need just one of you at a time, so please.
Well, let me ask that. How did you determine that it was at least a week old?
Objection, Your Honor. I don't believe that was the testimony. I think that's a mischaracterization of her testimony. She did not say it was at least a week old.
Mr. Malquist, response to that?
Judge, I think I asked her during the course that in her report she indicated that the injury was chronic and gave a range of 1 to 3 weeks. I want to ask how she came up with the determination of how it was at least older than a week old.
But, Your Honor,
Well,
respectfully...
Hold on, Ms. Moore. She's already testified that it could have been 5 days. So,
Okay.
I mean, I guess if you want to ask that
Well, let me
question,
ask, could it have been...
I will sustain the objection because it is a mischaracterization of her testimony.
Could
If you
that
want to
be-
rephrase that, I'm sure you can rephrase that.
Sure. Could that injury have been 3 days old?
Probably not. But again, bone healing is different and dependent on age of the animal. So I think it's not likely, but I can't say it's absolutely not.
I have nothing further.
Any redirect?
Yes, Dr. Rose, you indicated that the fracture was a complete break of the ribs in question. Is that correct?
Yes.
Would that impair a dog's ability to breathe somewhat?
It would cause pain during breathing because it would cause motion of the rib.
Okay. I have no other questions. Thank you.
Any additional questions, Ms. Malquist?
Nothing further, Your Honor.
Thank you. This witness may be released at this time.
Thank you.
Ms. Malquist, any objection to this
Can she
witness
go
being
and
released?
check
No objection, Your Honor.
Thank you. Maybe you can leave the building. Thank you very much. Next witness, Ms. Goldberg.
No further witnesses, Your Honor.
Do the defense have any witnesses?
None, Your Honor.
Okay, argument.
Yes, Your Honor. 1 moment, please. Your Honor, the people would actually move to amend to add the terms disfigure and maim to the complaint. I believe that is directly out of the statute, and I believe the proof...
You're not seeking to amend the actual charge, you're just the wording
Correct.
of the charge. Is that
Just the
correct?
wording of the charge to include torture, mutilate, maim, and disfigure. And I will get to my reasons
Okay, go ahead,
in argument. I do believe the people here have proven today by probable cause through the exhibit of the video and through the witness testimony that the defendant did mutilate, torture, maim, or disfigure a dog, in this case a dog named Meatball. The repeated forceful infliction of pain to numerous parts of this dog's body, Your Honor, with no legitimate justification presented to the court today is enough to meet the definition of torture itself. This was not done, as the court could see in the video, in a brief moment of anger at this dog. This was done over a period of time where the defendant even took breaks in between the beatings. The defendant went into his house in between the beatings, or left, at one point, left the yard and then came back. He came back to torture this poor, docile dog into further submission. I suggest to the court that it's important to look at the dog's body language. On that video was not an aggressive or even hyperactive animal. This was a dog whose body language showed complete stillness, complete docility and submission. The veterinary testimony supports the torture element, but also mutilation, maiming, and disfigurement. The dog had 2 broken ribs that were consistent with the defendant's infliction of the force. The radiologist estimated that the ribs were fractured in the time frame of, it could be 5 days to 3 weeks of the films being taken. 6 days prior to the x-rays was the date of the abuse, Your Honor, as was testified by Dr. Bagany. It's a pretty close estimate. It's right in there in that range. Certainly there's enough for probable cause. Now, as to the statute itself, it's not helpful in providing definitions of torture, maiming, mutilation, disfigurement. So statutory construction rules tell the courts that they must go to look at a dictionary to find a definition when it's not been supplied by the legislature. So I looked at Webster's Dictionary, and I looked at Black's Law Dictionary. In Black's Law Dictionary, torture is defined as the infliction of intense pain to the body or mind to punish or to extract a confession or information or to obtain sadistic pleasure. The Black's Law Dictionary definition of disfigurement is an impairment or injury to the appearance of a person or thing, such as ribs. The definition of mutilate is to cause severe damage to the body of a person or animal. And the definition of severe is very bad, serious, or unpleasant, or causing a lot of physical pain. I suggest to the court you've heard enough evidence to support probable cause for that word as well, mutilation. And maiming just encompasses, according to Webster's Dictionary, to mutilate, disfigure, or wound seriously. Judge, I think there's enough here. I'll save any further argument for rebuttal, but I think you heard a lot of evidence at this exam today. There's that saying that a picture speaks 1,000 words. Well, the video certainly speaks 10,000 words. And I ask the court to bind this matter over circuit court as it's charged and with the amendment.
Okay. Thank you very much. Response.
Your Honor, we are dealing here with a statute, and let's look specifically at 750.50B. It's the animals killing, torturing statute, Judge, and it makes it a felony in the state of Michigan to kill, torture, mutilate, maim, and disfigure. Obviously, we know Meatball survived, so killing's out of the picture.
So stipulated.
Your Honor, in regards to disfigurement, I didn't hear any testimony that Meatball ever had any sort of disfigurement. In regards to being maimed, I never heard any testimony at all that Meatball was maimed. And Webster's Dictionary of maiming is a permanent disability or disfigurement. There's been no indication that Meatball had any sort of permanent injury, was disfigured in any sort of way, that in fact that Meatball wouldn't heal.
Intent, isn't that the issue?
Judge, I don't think, I'm just getting to the point. Even if these issues regarding Mr. Sporer, because intents always are going to be a question of fact, Your Honor, but even if everything the prosecutor presented at evidence today was true, which is the way the court has to look at it during the course of a preliminary examination, it does not meet the level required into this statute, Judge. They would have to show, my opinion is that they're relying on torture, okay? And although there is no definition of torture either in the jury instructions, there has been case law. If you look at, there's a Court of Appeals decision, it's People v. Henderson, it outlines, in order for torture, there has to be severe physical, mental pain, agony, or anguish. Now, she says, look at that video, Judge, and see what's going on. And she says, remarks about how the dog is remarkably still and calm. That is not a sign of pain, agony, or anguish. A fact that if a dog or an animal...
Objection, Your Honor. I believe at this point he's offering testimony or opinion that did not come out.
Judge, I think I can...
I'm going to let him argue that. Go ahead.
I think I can argue it. I'm just saying, viewing the video, there was no evidence that this dog was in any pain or agony. Now you get to Dr. Bagney. She wrote in her report, the dog was not painful. The dog was happy. The dog, when she saw him, everything seemed to be normal, happy dog. She says the reason when she then sent the matter out for an x-ray, and then we've got these conclusions, Judge, from the x-ray that basically somehow almost eliminate the time period of when these fractures could have occurred. And there's been no testimony as whatsoever as to how... It's all mere speculation as to injury when this dog is. She indicated that the injuries could be anywhere from 1 week to 3 weeks in her estimate, but that's not an exact science. In fact, she said basically she would have a further range. Even though her estimate of 1 to 3, she said it could be different from that. So it takes it out even outside the time.
Isn't that a factual question, Mr. Malkowitz? Isn't that really a fact for a jury to decide?
Well, Judge, if they're asking you to determine what torture is, Judge.
Sure, okay, so that's just my decision, whatever I decide, so it's whatever I think torture is, that's what the law is. You've not really given me much of a definition. I know Ms. Goldberg's indicated what's in Black's Law Dictionary, but no case law, nothing other than
Judge,
it's my own reasoning what torture is.
No, Judge, I defined it as severe physical or mental pain, agony, or anguish. And the cases that involve these involve burning to death in the state of Michigan, not single strikes. And if you look at the standard definition of torture in regards to non-animal persons, it relies to sadism, things of that nature, and continuing, ongoing pain, attacks for days, weeks. This was not a significant period, Judge. This was not a 2-day-long attack on this dog. There's no deprivation of food, no deprivation of water. The dog seemed otherwise healthy. This incident lasted at most 11 minutes, and in the majority of it you saw in the video is plank time. So you're talking about maybe a couple of strikes, Judge, which if this would have happened...
So how much time does it take? How much time do we have to have? What's the standard? Is there a specific time period that you're arguing that it should be more than 10 minutes of continuous, or does it have to be more than 15 minutes or half hour?
I would think so, Judge, and have to get into anguish, just taking it as a common everyday. I don't... If the court has, I've never seen anyone charged with torturing an individual, and I've done a lot of criminal defense work for a few strikes here, and I don't think the standard should be set higher for an animal than it is for a person. And I just don't think, given the case law and the definition, there's been no testimony of any severe physical pain, severe mental pain, no testimony of agony.
How are we ever going to determine how much pain an animal goes through? I mean, how are we ever able to determine that? I mean, we can't ask the animal. We can't. I guess we could. Maybe someone could train an animal to tell us the amount of pain that they're suffering. I guess I'm not sure. But how are we ever going to know how much pain the animal's gone through?
Well, Judge, their expert, their first doctor said that the animal didn't appear in pain. When she saw him, that's after...
Certainly after the incident occurred, so it's like some 5 or 6 days later, so that's kind of not really relevant, is it?
Well, I think it may be, because if the dog would have been subject to a torturous attack, obviously the dog would have, I think, had to have some signs of being in pain shortly thereafter. We're not talking about just, I mean, if you look at the second count, where there's the cruelty to the animals, where there's a strike, where you're just basically charged with striking an animal or hitting an animal, that would be appropriate, Judge. But this higher animal killing torture statute sets the bar a lot higher. And it's their burden to show somehow, some way that this animal was, in fact, in severe physical pain. They have not shown that. Mental pain. You and I both agree. Meatball's not going to get up there and tell us how he feels today. But agony and anguish. Agony. The dog would show some signs of being in pain even 5 days later. Anguish. And this is just a case of overcharging, Your Honor. And they have...
So you're saying the prosecutor doesn't have that discretion to do that in this case because it doesn't meet the requirements of the torture?
Even if everything was true in this preliminary examination, it does not meet the legal definition of animal killing or torture.
And what again is that, in your opinion, what again is that definition?
Well,
I mean, you're not giving me really any legal authority whatsoever.
But Judge, I've given you the Henderson case, which basically defines torture in this statute. Okay, and that's People v. Henderson, and it defines it as...
Do you have a copy of that?
I do, Judge.
Have you seen that?
I am more than familiar with that case, Judge, and it is completely distinguishable.
Okay, well, we'll let you respond. Go ahead, Mr. Malkovich, I'm sorry.
And Judge, that gives the definition of, it defines torture. Basically says the statute doesn't define torture. We look to precedent, and it indicates, it gives a definition of torture as severe physical or mental pain, agony or anguish. Now, does it go further and define what severe pain is? No. Does it go define agony or anguish? No. But commonly, severe physical pain, I think leads more than just to having a bruise on your head. I think it would require severity. Mental pain, no testimony of that, and I don't know if we can get to that, but agony or anguish, also not defined in the case law, not defined in statute. Going through Webster's dictionary, Judge, I think we don't believe that agony or anguish were shown in any way, just by our local or regular common definition of those. So, defined in case law, severe physical and mental pain. And this, I believe that's the case that involves a burning to death, Judge.
Right.
I don't think I've seen a case in Michigan, Judge, where someone was charged with this crime, where there wasn't a death involved or something where you and I don't have to argue about what torture means. I think the facts in those cases were, you're talking about throwing animals into burning fires, things of that nature. I don't think there's been any case law about just, hey, an individual struck the dog 3 times over a 10-minute period and that arises to torture. I think that, in fact, that the legislation is trying to protect people from being overcharged by also having the abandoning cruelty to animals statute, which is the misdemeanor he's charged with. And that's what I think this case should have been charged with to begin with.
Okay, thank you. Ms. Wilbur, your response to that?
Yes, Judge. First of all, just as to Henderson, that case involves horses and a fire, and whether or not specific intent is required. That is the inquiry there. So I'm going to say that that case really isn't very relevant in this matter. But when we talk about evidence of pain and evidence of something actually happening and causing pain, and we talk about in the world of humans an assault, whether there was injury. The fact finder can consider whether there was injury as to whether or not certain pain, a reasonable inference from fractured ribs is that there is pain. And at preliminary examination, we look to what are the reasonable inferences. Plus, we had testimony of a witness who said it would be painful, uncomfortable, things such as that. And so I want to address the word of torture. And I'm going to ask the court, to put, there's so many connotations with torture. We think of what we see in the movies and in the media about waterboarding and things like that, and what is torture, but really the statute just gives us the word. And so by the rules of construction, we must look at the dictionary definition. Now, Mr. Malkovich has a slightly different one from me. I literally copied it right out of Black's Law Dictionary. The infliction of intense pain to the body or mind to punish, or I think the other one that's applicable here is to obtain sadistic pleasure. So here we have not just one strike or 3 strikes. We have multiple strikes with a fist. We have a kneeing in the ribs, side area, left side. We had multiple, I lost count, at least 7, taking the dog by the ears and just ramming it into the brick house. I mean, this is like repeated over and over again. I can't stress that enough. If that wouldn't cause an animal intense pain, or to use Mr. Malkowitz's definition, anguish to the animal, I don't know what other reasonable inference could come from that. And as to intent, it looks very much to me, watching the video, that the defendant wanted to hurt this dog. He was not trying to take care of this dog or use any sort of, there was just no justification. There is no other inference that can come from that, but that he wanted to hurt this dog. And you don't do what he did if you're trying to be kind to your pet. And so I think that intent is really, there's plenty for the court to find there. I have printouts from Black's Law Dictionary and Merriam-Webster if the court is interested in reviewing. But for purposes of probable cause, I think we have more than enough. I don't think the court has to find that the dog was beaten for days. As to the dog being still, I don't think that is something that would lead you to the conclusion necessarily that it didn't hurt. As to Mr. Malkowitz, I don't want to say he testified, but he argued that means the dog it didn't hurt that much. I argue that the dog wanted to disappear. that that dog was going to stay as still and as good as he could so that the defendant would stop. But he didn't. And I think we've met our burden. I ask you to bind over.
Well, let me ask this, Ms. Goldberg, before you sit down.
Sure.
You can
No, go ahead, Judge.
What about Mr. Malkowitz's argument, in fact, that you have a 3-count complaint, the first count being the torturing of the animal, which is a 4-year felony. Count 2 is the cruelty to animals, which is the 93-day, and also an unlicensed dog, which is a 90-day. But what's the difference between, is it just prosecutor's discretion as far as the cruelty to animals, which basically indicates if anyone beats an animal, then you're guilty of a misdemeanor of 93 days, but if you torture an animal, you're guilty of a 4-year felony. What's the difference between, is everybody who beats a dog, is that torture? What's the difference between beating a dog and torturing a dog? Is there a difference, or is it just a matter of what the prosecutor calls for, or what the prosecutor wants to charge the defendant with?
Well, Judge, I definitely believe that we have our discretion as the executive branch and as the prosecutor's office, but beating does not necessarily, the misdemeanor does not necessarily result in like an injury, is something I will consider. Here we had 2 fractured ribs and a 1 to 1.5 inch contusion on the head, consistent with what the video showed. So this wasn't just, not that I'm minimizing, but this wasn't just a beating. This was a pulling the dog up by the choker chain so that it's completely the tightest it could be around his neck, probably impeding his ability to breathe and certainly get away, and while he continuously beat down with his closed fist on the dog. And this is not, I don't know what a beating looks like in every scenario, but this repeated, this calm, it wasn't like an angry beating. This was the calm, I'm going to beat you, I'm going to push you into the ground or the deck, I'm going to grab you by your ears so you have no mobility, and then I'm going to walk back in the house or out of the yard. And then I'm going to come back and do it to you again. And then I'm going to go back in the house. So I have plenty of time to cool down. When I say I'm talking about the defendant, I guess I should be more precise. This is just sadistic. This is punishing, and that fits right into torture. Beating may not be purely that. Beating can be different. I'm not saying count 2 isn't applicable, but torture has a little more.
You think the injury is critical in this case?
It definitely weighed into my decision, quite frankly, if the court's asking.
Thank you. I'll let you respond, Mr. Malkowitz, even though it's not...
Just to comment, Judge, in regards to injury, I don't believe that the injury was caused by this, but I don't think the injury makes a difference. In Michigan, you and I know, if you injure someone during a fight, and we're talking a human, even if there's an injury, it's still charged as a misdemeanor, aggravated assault. The burden to get to torture between aggravated assault is, you're talking mile leaps, Judge, and it does not meet torture. It does not meet any definition of torture, and that's why it fails.
Judge, I don't want to open the door. I just want to say his argument.
I'll let you have the last word.
Oh, okay.
Go ahead. If you'd like to say one last word, I'll let you do that.
It just sounds to me like counsel's argument, with all due respect, is with the legislature. The legislature provided this as a 4-year felony, and it provided for torture, and it provided for the courts to use for their own definitions as found in the dictionary for torturing, disfiguring, maiming, or mutilating. So, you know, that's the law has given it to us. He may not like it. He may think that it's too serious for an animal. I completely disagree, but that may be his position. But that's what the law is, and I ask the court to follow it and bind over.
Okay, thank you. I've heard the testimony. I've heard the argument. Certainly, this is a case where I think both parties have that the legislature really hasn't defined torturing. So I think we have to look elsewhere for really a definition. And I've had an opportunity to review this Henderson case, which is a 2009 Court of Appeals case, and what that case basically, and I agree with Ms. Goldberg on that maybe not applicable in this particular situation, but it certainly gives us some definitions of torture and indicates right in the case that the legislature did not define torture in the statutory language. So we have to look elsewhere, and in that case they also looked at the law dictionary or Black's Law Dictionary and then also other sources. I've also had an opportunity that I've looked at, and for just some reference, because there is none in this particular statute as it relates to animals, but I've referred to MCL 750.85, which refers to torture of human beings, not animals, and not that they're the same thing, but certainly might give us some input or some reference to what really torture of an animal is. And that clearly says a person who, with the intent to cause cruel or extreme physical or mental pain and suffering, inflicts great bodily injury or severe mental pain or suffering upon another person within his or her custody or physical control, commits torture, and is guilty of a felony. And in that case, or in this statute, it defines cruel means brutal, inhuman, sadistic, or that which torments. We all know what custody or physical control. The mental, it defines severe mental pain or suffering. And once again, it's difficult to indicate exactly what the dog was feeling or thinking, or whether or not pain, what the extent of any pain might have been. But that's what the legislature has given us. I'm going to point to the one sentence, I guess, that's in this Henderson case from 2009. And what they indicated in that particular case, and once again I'll quote, it says, turning to the law of our sister states for guidance, we find that many have provisions specifically defining torture as it relates to their animal offense statutes. After considered review, we note that the term torture is commonly defined to include every act or omission that causes or permits an animal to suffer unjustifiable or unreasonable pain, suffering, or death. I think based on that definition, I think the people have met their burden. In fact, I am going to bind the matter over to the Macomb County Circuit Court on all three charges. Certainly the misdemeanors follow. But based on that, and based on the testimony of both veterinarians actually, and that of the neighbor, I believe the people have met that burden. So we're going to bind it over. I'm sure that the pretrial arraignment date, are you picking June 27th at 1:30? Is that the date that you've chosen, or is that?
I'm sorry, did the court say July 5th?
Oh, is that what you want?
I think now that it's Thursday, we have to go to the next
You
week.
know more about it than I do, Ms. Goldberg. So is that at July 5th at 1:30? Is that what it is?
I'm fine with that date,
Okay.
Judge.
That's your pretrial arraignment date is July 5th at 1:30. Anything else that we need to address, whether it's related to bond or anything else at this point in time?
No, thank you.
No? Anything else, counsel?
Nothing further, Your Honor. Thank you.
Matter found in your County Circuit Court.
Do you need the waiver form?
Yeah, I'm sorry, looking for the case number. Please, well, I feel like you're going to be the custodian now. And Dr. Speaking will want to look at those, our forensic. Yeah, it's what you want us to do. But it makes sense, you guys should have them. And Jason may want to, and Carl may want to look at those too. And,